Hi, my name is Eric Olson, Director of HELPS. This little video is going to talk about what happens when a senior is served with a summons complaint or sued, and do they need to be concerned. The first thing I want to explain, and seniors need to understand, is that federal law protects your Social Security, your pension, disability, VA benefits. Social Security is protected by Social Security regulations. Pensions are protected by a federal law called ERISA, passed in 1974, and VA benefits are also protected by other federal laws. It can't be garnished from you. They can't go to the government or your pension and take this money from you. So that's the first thing seniors are worried about if they're served with a lawsuit and they owe money and they're worried, oh no, someone's going to sue me and get a judgment and they're going to be able to take my money. Well, the answer is, in the vast, vast majority of cases, absolutely not. Well, the next question that seniors have, okay, if they get a judgment and they can't take the money out of my Social Security or my pension, what about my bank account? Can they take it from my bank account? So let me explain why you're not going to have to worry about that. About 5 years ago, the federal government passed regulations that protect twice the amount of a person's Social Security deposited into the bank account. Okay? So, and no matter what funds are in there at the time, if a garnishment took place. Okay? So I'll explain that. So if you get $1,500 in Social Security and you times that times 2, that's $3,000. What that means is if that Social Security is deposited into your checking account, $3,000 in that checking account is automatically protected if the bank or credit union received a writ of garnishment, and that's an order that the bank gets from a creditor that has a judgment that says, hey, if you have holding money for someone, you got to give it to me. If that happens, the bank looks at your bank account, and if they see how much Social Security went in there, they times it times 2, and whatever that number is, it's protected. It doesn't matter where the money came from that's in the bank at that time. Doesn't matter. It's just the Social Security amount times 2 is protected. Now, if you have more than that in that bank account, it's possible that that excess money could be temporarily held up. You would have to file a claim of exemption or a challenge to garnishment. That's a paper you file with court that explains to a judge why your money is protected and where it came from, and it would then be released. We do that all the time for our HELPS clients. Usually takes a couple days, but a lot of our seniors just simply do not have more than twice the amount of the Social Security in the bank account at any one time. Most of them haven't been sued, so they don't even need to be worrying about that. Now, so what happens if you have more than that in your bank account? Let's say you have a small amount of Social Security and a big pension. Well, one way to solve the problem so you don't even have to worry about it is see your pension is downloaded on a debit card. It doesn't go into a bank account. There's no way for a creditor to garnish a debit card. It just cannot happen. So, and debit cards can be used just like cash. So that explains, what people are really concerned about at first. But if you've never been sued before, and someone comes to the door and gives you what are legal papers that you don't understand, it's absolutely common for you to be really scared or have concerns, and I want to explain why that isn't a concern. First off, the person that gives you the paper, sometimes it might be a sheriff's deputy, and you'll think, oh no, I'm really in trouble. Well, not so. Every sheriff's department in the country has a deputy that is what's called a civil deputy. He is assigned to serve legal papers on people, like a lawsuit or summons and complaint. He gets paid a fee for doing that. And that can usually be done by a private party, or it can be done by a sheriff's deputy. So just because a sheriff's deputy knocks on the door and gives you legal papers, you don't need to be worried. Now, when you get the papers, you'll look at them, and it'll say, if you don't do such and such, they're going to get a judgment against you. Usually there's 2 papers, a summons and complaint. And you usually have what it says, a certain amount of time to contest this lawsuit. And it's probably either 20 days or 30 days. If it's a small claims court, it might be 14 days. Depends on where you live. For most people, they owe the money. A credit card, for example, and they think, do I need to go to court? And the answer is, well, no. If you owe the money and you don't and there's nothing to contest, you don't need to do anything. They're going to get a judgment. I've already explained that they can't take your income, so that's nothing to worry about. So if it's a debt that you do contest, then you always have the right to file an answer and dispute it. And that's where it goes in front of a judge, and he can make a ruling whether you owe the money or not. But for most seniors, they owe the money. They're judgment proof, which means no one can take their income. Therefore, there's no need for them to be concerned. They don't need to file an answer. Now, a lot of times seniors, when they get the paper, they'll have a date on there. It'll say some date that you're supposed to appear in court. Well, if you read that carefully, that says that if you file an answer or contest it, then you need to appear in court at that time. But if you're not going to contest it, then absolutely no need to appear in court. So if you've been served for the first time with a summons and complaint by a creditor for money that you owe, no, there's no need to go to court. They're eventually going to get a judgment. Now, we represent seniors to stop collectors from harassing them. Once in a while, our clients will get sued. And I explain to them that it's not personal. It's just a kind of a computer that's running the thing. The creditor probably already got a letter from us explaining that their income was protected, but the computer sometimes can't read that or understand that, and they just sue people automatically. For example, Discover Bank in the last year has been suing a lot of people, whether it's going to be collectible or not. They just do it automatically. So you don't need to feel that it's personal or that you're in big trouble or anything, because you're not. They cannot really do anything to you. So if you do nothing, they're going to get a judgment. Sometimes, and I explain to you why your bank account is protected. So the next thing seniors worry is about, especially seniors that are buying a home, they're worried that the judgment might become a lien, and they're scared when they hear that word, or they read that a judgment will be a lien on their property. Well, it is true in most jurisdictions, a judgment will become, either automatically or by filing some other papers, a lien on a person's real property. Now, what I mean by that is a home that sits on land. Okay. Now, in a few states, the lien can be on a mobile home, but normally it's just a lien on the home that sits on land. And in the vast majority of cases, that's meaningless, and I'm going to explain why. So it's only a lien to the extent the person has equity in a property. So if you've got a property and you owe $100,000 and it's worth $70,000, then there's no equity, and the lien is absolutely meaningless. But let's say that you've got a home that you owe $100,000, it's worth $150,000. So you got a $50,000 equity. Sometimes seniors are worried, oh no, someone's going to take my home. Not true. First, every state has what's called a homestead exemption, and it varies from state to state. Some states have very generous homestead exemptions, like Arizona, Texas, Florida, Oklahoma. Some states have homestead exemptions that are smaller amounts. And what that means is the amount of equity a person can have that's protected from creditors, normally when a bankruptcy is filed. And that can vary from state to state. Some states it's $10,000, some states it's $20,000, some states it's $50,000, some states it's $100,000. And you can Google your state homestead exemption and find out what the homestead exemption is for your state. You don't need to be scared if you've got equity way above the homestead exemption that the creditor's going to come in and take your money. I'm going to explain that. I'm an attorney for 40 years. I can never recall one instance when a general creditor, like a credit card company, has ever, when they got a judgment, attempted to take a person's home because they had equity over the homestead. It just doesn't happen. It's very difficult for them to do it, and for a lot of reasons, it could be stopped in different ways. It just doesn't happen. So don't let anyone scare you into thinking that if someone's going to get a judgment and you have a home with some equity, that you're going to lose your home. Not going to happen. They're hoping that someday when you sell the home that they'll get paid at that time. And they may not. There's different things can happen. So a judgment on a home is generally, in virtually all cases, not an issue for a senior to be concerned about. Now, sometimes seniors worry that a creditor is going to come in and seize their personal property. Okay, and in virtually all cases, that is not a concern either, and I'll tell you why. In every state also has a list of exemptions for personal property, like furniture, clothing, books and apparel, jewelry, and sometimes many states have what's called a wild card exemption that covers anything else that's not otherwise covered. So creditors that get civil judgments normally will not pursue a person's personal property, definitely not a credit card debt. Now, once in a while, a small collection company might try to intimidate a senior into thinking they're going to do that, but I just don't see it happen. Okay, they would have to file what's called a writ of execution, requires that they get a bond. They have to pay a sheriff a bunch of money, and it can be stopped by various means. And they've learned by the school of hard knocks that whatever property there is there, it's not really worth anything. Used furniture and used clothes or whatever person has, it's not exempt. It just has very little value to it. So generally, there's never any concern for any senior to be worried about someone coming in, especially lower income or poor seniors. It's just not going to happen. No one's going to come in and pick up their personal property. So that's a reason not to be concerned. Now, if someone gets a judgment against you, it is theoretically possible that a creditor could want to find out more information. They don't know that your income is protected, and they might send you some type of inquiry to ask questions about your assets, which can be answered. And occasionally, you might get served with a piece of paper. It doesn't happen very often, but very rarely. It's called a debtor's exam. And that's the only thing you need to be concerned about, because that's an order by a judge that instructs you that you're to come into court and answer questions from this creditor about your assets. Okay? Now, the reason that's important is if you don't appear, and you could be cited in contempt, and if you don't appear a second time, a warrant could be issued for your arrest because you've disobeyed a judge's order. So if there's ever a debtor's exam where that's a piece of paper signed by a judge ordering you to appear at a certain time and place, you need to be concerned about that. With HELPS, we've got thousands of clients. Maybe a couple times a year, clients will get a debtor's exam. The creditor usually knows that we're involved in their exam, so they don't even bother them. But in those cases, we'll contact the attorney and we'll explain the situation, give them some proof, and they back off and don't do anything. If they want to do something, we would appear with them or get a pro bono attorney to appear with them where they live. But that just doesn't happen, hardly ever. But you want to be aware of a debtor's exam. That can be important, but don't worry about it. It's highly unlikely that would ever happen. And as I explained, your income and assets are protected. They can't do anything anyway, so there's nothing to be concerned about. So, in summation, for most seniors that are lower income and modest income seniors or poor, the judgment is absolutely meaningless. They cannot do anything about it. And if you have any questions or concerns, you can call HELPS at 855-435-7787. That's what we're here for. We help seniors all over the country. We protect them from collectors harassing them. We send what's called a cease and desist letter, and the creditor can no longer contact you by phone or mail. They have to contact us. They have to leave you alone. And then we're always there to talk to our clients if they're worried or scared or have a question. That's what we're there for. We're their attorney on an ongoing basis, so they don't have to worry about collector harassment. And there's more articles on our website, www.helpsithere.org, about this topic. This is kind of a general explanation. There are exceptions. Don't consider this legal advice for every specific case, but it's a general explanation of the law in this area. And you have a great day.